This guy should be ready. You
Yeah,
have great
Good
voice.
afternoon. This is the House Transportation Committee. It is May 13th. And we have our Vice Counsel in the hot seat, Damian Leonard. And just a quick update. I'm not sure if this was related to you, but last week when the committee conference signed off on the transportation bill, there was a section pertaining to trails and the potential maintenance or lack of maintenance regarding trails. That was agreed upon the conferees to take it out of the transportation bill. And we promised we would have further discussions on whether or not we would include it in the DMV bill. So here we are, and I'm gonna hand it over to Damian if there's any updates or any new information that he should know regarding trails.
Sure. Thanks for the record. I'm Damian Leonard from the Office of Legislative Counsel. I think the Vice Chair summarized where we stand pretty well. You have some additional testimony after me today, and then more testimony scheduled for at least Wednesday and Thursday of this week. My plan today was just to come in here and answer questions that are outstanding. I know there are a variety of questions and issues kind of percolating about this, so I'm available to answer questions, and I think you've got me for a half hour here, and then I'll be around during the witness testimony this afternoon.
All right, Representative Fauci.
So what came out of the T-bill as far as the trails go, this is the language exactly the same still?
Well, it could be what we want it to
Right,
be.
right.
It is pulled out, and it very well could be the exact same language. There was a proposal to do a delayed enforcement of or enactment of by a year. So there's different options, but the agreement was that we would obviously continue the dialogue for the DMV bill. That would be in any shape or form as far as how we want to shape the language.
And the reason for delaying would be that perhaps the court case that's sort of entwined in this would be settled by then?
So the thought behind a delay is that it provides potential for there's a couple of sort of different approaches. If you go forward with the language with a delayed effective date, the thought behind the delayed effective date is that may give time for at least the trial court to issue a decision. It likely would not be enough time for the trial court to issue a decision and then an appeal to go through the Supreme Court if you did like a 1-year delay, for example. But the potential concern if you go, well, one of the potential concerns if you go ahead with the language right now is that it could result in the court deciding that the issue is moot because the law that it's been asked to declare, decide what the law means, has actually changed, and therefore the question in front of it is no longer appropriate for adjudication, which would mean that a new lawsuit would have to be filed, and that would be, if it was filed, would likely be an inverse condemnation lawsuit, which is a lawsuit arguing that the state has taken property without compensation or municipality has taken property without compensation. And then you go back to the first question of, was there any property to take? And then if the answer to that is yes, then you go to the next step of determining what appropriate compensation is. And there are a variety of ways to do that. Generally, you look at fair market value. With some things, there isn't always a fair market value that matches up to the property interest at stake. But yeah, so the question in front of the court now is, who has the right to maintain under the existing law? And if you moved ahead with the change that was in H488, and also in S4, that would go ahead and change the law prospectively to, depending on your perspective here, either clarify the municipality's right to maintain those trails or to provide municipalities with the right to maintain those trails. And then the court would be back essentially to square one with a new lawsuit. There is always a chance that the court decides that the issue is not moot because there are legal rights that are still at stake and it proceeds with it. I don't want to make it sound like mootness is a foregone conclusion. It's not. There are a lot of considerations that go into this. The court tends to weigh the law in front of it and the issues that are presented by the parties and whether a decision on that will have a meaningful benefit. But it is not unusual for a declaratory judgment action to be mooted by a change in the law while the action is pending. So.
Can I keep
Yeah, no,
asking
absolutely.
questions?
Yeah. No, fair.
So if we did nothing and the court decided, about the trails, the landowner or the court could say, yes, the town has to provide, some compensation.
We're not at that point yet.
But it could go there no matter what we do here.
Not so.
If the court says.
If the court says
towns
that
have the right of way and they have the right to, maintain it.
then there's no compensation needed. So we have a funny sort of multi-step process that has to happen here. So if the court decides that the right to maintain the trails lies with the landowner, what it's essentially deciding is that in 1986, when the General Assembly recodified Title 19, it relinquished the right to maintain public rights of way that are trails, legal trails, not any other kind of trails that are former town highways. It relinquished that right to maintain them, and then it went back to the landowners, which means that to get it back, the government has to pay for the right. So if the court decides in favor of the town, and the town's argument is that the legislature wouldn't have done that because a right of way without the right to maintain it for the purpose that it was granted for is almost, it's illusory and potentially without value, because if you can't maintain the right of way, then you can't travel along it. And the landowners' briefs argue otherwise, and so I don't want to get drawn into this too much, but if the town is correct, then they've had the right to maintain all along. They don't need to pay for it. So if the court in the existing case rules in their favor, there is no takings claim, there's no condemnation needed, nothing. The right to maintain is with the towns. If it rules in favor of the landowner, then in order to get that right back, the state and or municipalities will have to compensate landowners for that right. So if it does rule that the legislature decided to relinquish that right 40 years ago, then it now is going to cost the public money to get that back.
So that could happen even if we don't do anything.
Yeah, so the case is pending. If you do nothing, the case will work its way to the end.
And could be several things. Could be that, hey, the town has the total, they have their right of way and they can maintain it. And, maybe it goes up to the Supreme Court and they might say the same thing. Or they might say, all right, they have a right of way, but they never were given the right to.
They lost the right to maintain.
They lost the right to maintain it. So that could all happen whether we do anything or not.
Yep.
Now, if we go forward with this, does that change that?
So there are a couple of ways it can change that. So one is that one, if the court decides not to dismiss the case as moot, so decides not to decides not to dismiss the case as moot and proceeds to the finish, we get to the same question. Does the town have the right to maintain or not? The only difference here is that prospectively, we've granted the right to maintain or clarified it, depending on how the court comes out. But if it comes out in the landowner's favor, we've already granted that right and we have not provided compensation for it. So now we're in a place where you potentially have inverse condemnation claims against the state saying you should have condemned this and gone through that process. So now we're going to sue you for compensation for taking that right. If it rules in favor of the town, no problem. There's no issue. It's in effect clarifying the law. The other option, and this is where things start to get more complicated as we get more scenarios, is the court dismisses the case as moot because we've changed the law while its declaratory judgment action on what the law means was pending. Then what happens is the landowner or someone else would have to come back and file an inverse condemnation claim, which has the same question at the heart of it. Did the legislature give up this right to maintain in 1986? If the answer is yes, then they go to the second step, which is figuring out compensation. If the answer is no, they rule against the landowner, towns don't have to pay compensation, and you just move forward. So in all of these, it's a variation of this. Either they rule for the town or they rule for the landowner on who has the right to maintain and determine how these trails are maintained. Determine whether, when, how, all of that.
If in 1986, the legislature wrote the law and added maintain at that point that we could maintain, then because we've already had the right of way, because we already had the right to maintain what was there before, now that it's turned into a trail, the towns have the right to maintain it.
Yeah, there's been no.
It didn't slip through their fingers, I guess.
Yeah, there's no question that with public highways, town highways, there is an express right to maintain that lies with the towns. They can determine when, whether, how it's maintained. For class 1 and 2 highways, there's a clear obligation and duty to maintain. Maybe for class 3 as well, I can't remember. Class 4, it is at the town's discretion. So the town has discretion to maintain or not. The only restriction on that discretion is it can't maintain class 4 roads in a discriminatory manner. So for example, you can't only maintain class 4 roads for people who are your friends. Would be a great example. And there was a case about how the roads were getting maintained for folks who were friends of, I forget if it was the foreman or the select board member or whoever, and other folks were not getting their roads graded and filled, et cetera. And prior to 1986, trails were lumped together with class 4 roads. Town has the right to maintain, but not the responsibility or the obligation or duty liability. And the town's not liable for the condition of these trails. So in other words, it's trail. It may not be well maintained. But then after 1986, when they split the language out, the maintenance language didn't get added with where the trail language ended up. And so then the question has been, inherently a common law, a right of way comes with the right to maintain it for the use for which it was granted. The problem is that our towns are creatures of statute. And that's where the whole argument stems from, is that because we're a Dillon's rule state and towns are a creature of statute, did the legislature intend to give up that right? Or was this just an oversight?
I have one more question. hopefully this is helpful for everybody. Could they go back and, I mean, they don't have YouTubes of what the legislature talked about. Could they go back and is there a record of, you know, discussions and
There are some records.
somebody crossed it out and passed it, then that'd be one thing, but if, you know, hey,
There are some records. The landowners, attorneys have argued in their briefs to the court, based on some conversations that occurred in the predecessor to the current Senate Transportation Committee, that there was discussion there about issues of costs to the town of maintaining class 4 roads and trails. And that this decision to take away the maintenance authority was their argument based on those conversations is that it was an affirmative decision because of the costs that were being associated with that and the concerns about town budgets. There is some clear history about costs that towns were experiencing back then. What's not clear is whether, at least to me, what's not clear is whether this isolated legislative conversation actually shows clear intent. Tucker and I have searched the journals from the 1986 Act, and we haven't found a floor speech, for example, where the chair of the committee says, you know, and we've taken away the right to maintain trails because we're trying to save our town budget. So what we have is a conversation between a couple of individuals from the Agency of Transportation and some senators on the predecessor to the Senate Transportation Committee talking about expenses for roads or maintenance of town roads, particularly class 4 and legal trails, and the possibility of getting sued for not maintaining them. So.
What's that?
yeah.
Representative Burke?
Yeah, but so they didn't explicitly confer the authority to the landowners. In other words, they left out the word maintenance, but they didn't say, and we give this authority to the landowner.
No, they didn't expressly confer it, but there is statute that says when you discontinue a right of way, all of the rights in it revert to the underlying landowners. And if it runs along a boundary line, it splits between the two underlying landowners. And I mean, one of the other things to kind of keep in mind here is there is a whole bunch of common law around rights of way. So it's very common for rights of way to just be an easement over someone's land. So you've probably heard people talking about, well, technically my property line goes to the midline of the street or something like that. And there's a whole series of cases where, for example, folks, when the road was in poor shape and an accident occurred, they tried to sue the landowner because the road was in bad shape. And the court said, no, the landowner has no duty and in fact, no right to maintain that road. That is the town has the right to the road and the easement, and it's up to them to maintain it and keep it safe and passable. You know, but on the other hand, you also have other cases that say, yes, to the extent that the right of way is filled up with the roadway or whatever it is, the landowner can't use it for another purpose, but it also doesn't extinguish the landowner's rights within the right of way. So for example, if the town fills up 26 of 49.5 feet, the landowner can plant flowers and shrubs outside of that roadway. And many landowners do, but then if the town needs to widen it, it can clear those shrubs out in order to widen the road, as long as it's within the right of way. So there's a variety of cases about this, but the underlying law for our purposes is that when you discontinue a road, all of the rights in it that accrued to the town revert to the landowner. And so that's also at the core of this. If the legislature intended to discontinue the right to maintain the public right of way and just retain the right of travel across that right of way, then it would have reverted back to the landowner.
Representative Kuzic?
Thanks. So to just start something, so we have the right to go over the right of way. And we have the maintenance issue.
Mhm.
So we did, in the current facts, is the right of egress extinguished?
Nope.
Okay, so that means people can use this right of way.
Mhm.
Okay, so that right of way is not going to go away. I mean, unless there's I guess I'm tying myself up in knots here, but.
So it's not able to go through it.
Yeah,
Yeah, you'd be able to go through it, but you can't maintain.
No, I mean literally, because it's, debris and trees and rocks and stuff.
Right.
and that's one of the issues that's been raised in the litigation is if you hold a public right of way, a right to travel, but you don't have the right to maintain, you are at the mercy of whoever holds that right to maintain to ensure that it's actually passable. Because there is another long string of law that basically holds that the authority to maintain a public right of way is in the public entity that holds that right of way. So even though that it's held for the benefit of the general public, so everyone has a right to travel across it, the only person who has a right to maintain, or entity that has a right to maintain it, is the municipality or someone who's designated by the municipality, or whoever the public entity is. If it's a state road, the state. If it's a county road, in states that have county roads, it's the county. So in those instances, it's sort of generally accepted that you can do things like if there's a tree branch across the road or the trail, you can move it off to the side of the trail, but you can't come through and do major surface repairs or widen the trail or cut trees along the trail unless you are either the public entity that owns the right of way or you've been authorized by them to do that. Because as we know, for many of our towns, you'll hire a private road contractor to come in and do the construction.
Set Representative Kuzic?
Yes, thank you. Excuse me.
Okay.
I still am confused.
Okay, a couple questions. Damien, you said, referring that there is some language in existence that when you discontinue a right of way, the land reverts to the landowner.
Yes.
So is this case, and are we considering only land that has not been used as a right of way? Or all
So
land? that
legal trails are public rights of way that are formerly town highways and have just been, I call it downgraded to a legal trail. But they're no longer a town highway. They've just been a trail. So it's still, unless when they reclassified it as a trail, they said, and we're narrowing the right of way to, let's say 2 rods, so 33 feet. They're all 3 rods wide, 49.5 feet. Because as we all know, 16 feet, 6 inches is a rod.
Nobody knows.
I
never knew that.
And don't ask me how long a chain is because,
8 feet or something.
yeah.
It's a town.
Yeah, you know those.
But yeah, so the way the statute reads is it specifically defines a trail for purposes of town highway law. So the legal trails is simply a public right of way that is not a highway and that was either previously designated as a town highway and has the same width as that town highway did, or a lesser width if it was designated with that, or it can also be laid out as a new public right of way, in which case it could have a different width. But as I understand it, most legal trails, I don't know if all, but the majority of them are former class 4 roads that have just been reclassified as a trail. for a variety of reasons, depending on the town. So with some towns, it's a question of maintenance and use.
Yeah, I guess my question is,
Yeah.
let me clarify. There are a lot of right of ways, town roads, whatever we're calling them, over 500 in Vermont, from what I
Yep.
understand. And is this case regarding only the ones that are being currently used, or all of them? Because I'm assuming that
It's
there are
all of the
some that
mapped
aren't
legal
used.
trails.
All the mapped legal trails, regardless of whether they are currently being used by the public or not.
Right, they're all public rights of way. So in the same way that a class 4 road, it remains a class 4 road, whether or not a car goes down it. As long as it's mapped and designated as a class 4 road. That's the same thing with these trails until they're discontinued
Okay.
altogether.
And where can we look at the most recent version of the language for the bill?
And the side by side still there.
Yeah, it is in the side by side of H4.
It's been a while.
Yeah.
But if you look up Damien,
Union Side by side.
Yeah, so if you go to your committee webpage, it'll be under documents that I posted or that Cam posted for me.
If you go to bill and then it should be under S1. Or actually page 48, and then
Yep.
the drafts amendments and other legal documents.
Would it be helpful if I pulled the language up for everyone and put it on the
Sure.
screen?
Did you have a question based off that?
I just wanted
Alright.
to pull out the most recent language and, okay, Cam, tell me that.
Yeah, whatever.
I'll email it straight to you.
Lally and then Representative Pop.
Damien, so it sounds like there's flexibility in these sort of tiers of road classifications. So could a class 4 become a class 3 or a class 2? I mean, I know we see that sometimes.
There's a reclassification process.
Right. So how do trails fit into that? Could a trail be simply reclassified as a class 4?
Yeah, it could. The interesting thing with this case is that, again, if the legislature gave up that right to maintain in 1986, part of that reclassification would require an eminent domain proceeding. If the
Right.
legislature didn't give that up, then you can just reclassify back to a class 4 road and then the town would improve the surface and so forth.
Right. It seems like in 1986, there was interest in creating a kind of a subcategory perhaps. But I guess I'm wondering if the inherent rights that came with the original creation of these right-of-ways, which have changed over time and evolved and devolved and evolved, if those remain, and if that's, I guess I'm just struggling with it seems illogical to me that there would remain right of egress and these would appear on official maps, public maps, yet there is no right to maintain, which effectively means you can't guarantee that you have the right to, the ability to use them. So I'm just struggling with.
And that's one of the arguments that's raised in the litigation by the towns is that having a right to travel when you can't maintain for that right to travel, and you're at the mercy of a third party to determine whether and how and to what extent the right of way is maintained. There's a question of, does it make sense?
Yeah.
Would this be, and this is, again, in the litigation, I don't want to get too deeply wrapped up into it, but they're raising different arguments about statutory interpretation. And this is one of the things about when we argue statutory interpretation in courts, there are a number of competing, what we call canons of construction. And when you hear canon, you may think, like Catholic canon law, like this is really firm, but really it's canons of construction are just different tools that are used, and depending on the judge and the case, you will see different canons preferred and used. And so one of them is that there is one canon that says when a legislature includes certain words in one place and doesn't include them somewhere else, it intended them to have different meanings. Then there's another one that says a legislature will not do something that would lead to absurd results. So we won't interpret a statute in a way that leads to absurd results. And so you can imagine here, each party is utilizing one of those arguments and then other arguments on top of that. That's not the whole case, but this is among the, assorted arguments that they've raised for the court to consider. And so there are questions about that and questions about the viability of, having a third party have the authority and responsibility for maintenance and not having it lie in the holder of the right of way. But yeah, it is a valid consideration.
Thank you.
Representative Tomlinson, or you were first.
Yeah,
My bad. Switch that up.
I assume that some towns have maintained these legal trails.
That's a better question for the League of Cities and Towns or some of the other folks who are going to come up here. My understanding is yes, some towns do maintain them, but I really don't know the specifics, and I think it's a better question for folks who do know.
Representative Tomlinson.
So between 1986 and now, before this lawsuit, was there any other sort of indication that there was an alternative interpretation of the law or any other challenges to it? This is the first time this has come up.
To my knowledge, this is the first time that this specific question has come up. About 20 years ago, the issue of unidentified corridors came up. And what that was basically class 4 roads and trails that didn't appear on the town highway map, that some called them ancient roads. And so there was this question of what essentially had happened in a few instances is someone would build a house only to find they built the house across a right of way. And then they had to, were either being asked to move their house off the right of way or having issues with like the right of way literally running, through the very front yard of the house. And so the legislature in the early 2000s enacted a law which basically provided for the mapping of those unidentified corridors and the extinguishment of corridors that were not mapped by a certain date.
Okay.
So that's the closest we came to this issue. So think of it as like a parallel issue where they might have touched on each other a little bit, but it wasn't the maintenance issue.
Yeah. And so while this lawsuit is in progress, is there any impact on other towns and their access to, like, in before the decision, like while this is just underway?
So this is something that I think you'll get different answers from different people. So it's probably a better question for the advocates. I know that testimony has raised uncertainty and concerns about that, but it really is a better question for you to ask the towns and the other trail groups and the other advocates in this group about what the impact is on them.
Okay, but legally, the understanding has been for the past 4 years that they have the right to maintain, and so they, under current sort of.
So my understanding is that at least some towns have understood that they had the right to maintain these. Again, I can't speak for the towns. Yeah, I think anytime there's a lawsuit pending, It's sort of a proceed at your own risk moment, where, you know, you want to sort of balance what's the potential, what's my potential liability
Mhm.
if I move forward with this. And sometimes, you know, the answer is pretty minimal, and sometimes the answer is this could be pretty bad. And a lot of that's going to depend on the specific facts that each town in this case is facing with their trails and the relevant landowners and their maintenance plan and so forth.
Mhm.
And so, you know, if the town doesn't do maintenance as a policy, then they can just keep going the way they do. If they do, they are going to have to consider, you know, is it likely that the landowner may sue us? Is the maintenance valuable? But that's really something that they can speak to more.
And just finally, just to make sure I understand, so if the court rules that the legislative change was intentional and that towns don't have the right to maintain, does that effectively mean that towns across the state would immediately lose access to maintaining trails or utilizing trails?
These trails, yeah.
Right, so the
yeah.
legal trails.
Yeah, yeah. So that's the other thing. I just want to be clear. These legal trails are a creature of highway law. They're different from vast trails and VASA trails and landowner agreements with local mountain bike associations or hunters, et cetera, to allow use of land. And they're different from the easements for the Green Mountain Club for the Long Trail, and for the Appalachian Trail and so forth. And they're also different from trails that you find in your state forest or your town forest or other public lands where it's publicly owned. And so the public entity determines that. And that's one of the complicating factors here is there's a lot of different types of trails, but this is one specific subset that is a little over 500 miles of trails in this state.
And that's regardless if we pass this amendment or clarification of maintenance. If they rule in this guy's favor, regardless of what we pass, you're still gonna have that issue of compensation, correct?
Right. Yep.
Representative Casey and then the Representative Burke.
As Forest, I was at Forest Parks and Recreation when they have some concern over this, don't you think?
There, again, you should speak to Forest Parks and Recreation about what their concerns are.
I think we've received emails from just about everybody. Running on basis.
We get them in, you think? Just somebody just, I haven't heard nothing
Yeah, if
from
you
them.
have, yeah, I'm happy. to-
Yeah, you know, I think if you look at the map of these legal trails, they're not, you know, they tend to be in the mountainous areas where there probably were roads at one time to get to some farms. And then they stopped using them, and so there is a map that shows them all. But you know, they're not part of, well, they might go to
So,
a park, but
What I was worried about is like, don't we have trails that kind of mull into different jurisdictions as, I don't know if that's the right word, I'm not a lawyer, but you know, just kind of like if you're on state land and, you know, I'm not sure how many times this happens, but isn't there like state land that runs into old town roads and stuff? Wouldn't that make an effect to getting into access to some of the?
Yeah, so there's actually a statute that addresses what you're talking about, and I can't speak for the department. But right up here behind me, anytime you're going to discontinue a highway, the select board has to notify the commissioner of Forest Parks and Rec. Because the select board can either designate the discontinued highway as a trail, or the commissioner, with the approval of the select board, may also make that designation. And my understanding is that the commissioner may want to do that if the trail is on a class 4 road or would be along a class 4 road that used to provide access to state forest or state parkland for whatever purpose, whether it's recreation or maintenance reasons. And so again, I have to let Forest Parks and Rec talk for themselves. my understanding is that there are some legal trails that, among other things, provide a way into state forest or state parklands. And so, yeah, there is an impact there.
I'd be definitely concerned about losing any trails, to be honest with you. I mean, I obviously don't walk around on every trail, but somebody does. You know, in the 1980s, I don't remember everybody being into the big exercise kick they are now. You know what I mean? You see more people walking and, you know,
We're running.
yeah, running, bicycling, everybody's getting new knees and. I don't remember that happening when I was a kid, and I remember my mother just reading books and dad would go about his business and go hunt and stuff, but it wasn't like, hey, you kids need to go out and exercise. We didn't really hear that, but you know, I did anyways for bicycling and drive my neighbors nuts, but I just, I don't know where I was going with all that, so I'll stop right there, but yeah, I'll leave you guys alone.
Representative Burke?
I was just gonna say, it's sort of interesting. I've been reading an article in Vermont Public about that it sort of gives context for what happened, that it was a bicycle race that was supposed to go through the trail that's unprompted the whole thing. And, it seems like, anyway, it's just interesting to read. I just go to Vermont Public, it just gives you what's actually happening, aside from all the legal issues.
Did it make any difference if we did retroactive in 1986? And was, we passed legislation retroactive, we do that all the time, or would that have any bearing?
That's quite a way.
It definitely wouldn't for this case. I mean,
Or any,
yeah.
Yeah.
So we do pass retroactive legislation, usually not your retroactive date, or retroactive effective date. And there is definitely, it would raise a whole bunch of questions that I'm not sure what the answers are to, but I do know that from the standpoint of like pending lawsuits, courts really tend to frown upon the legislature trying to go back and change the facts to suit the outcome that it wants. In terms of like retroactively changing the law that was in effect at the time the lawsuit was filed. And so they usually let those lawsuits proceed.
Not changing it, clarifying.
Right. So,
That's what this is doing, but it's not.
Yeah, actually,
Yeah.
I meant to put in the word maintain.
Yeah.
and there are clarifying, there's clarifying legislation that's retroactive all the time.
Yeah.
But again, I've never in my career seen one with I guess it would be 39-year retroactive effective date. But I would just, wonder, are there other legal issues potentially raised by such a long retroactive effective date? I've read, dicta, which is judges sort of waxing and going off on a little bit of a tangent from the case where they've speculated about how far back retroactivity is, but and a lot of times though that relates to the facts of the case, and I wouldn't want to.
Yeah, no, fair enough. I just throw it out there if that's a possibility, but do you want to wrap it up?
And yeah, and that's sort of related. I mean, does it, if we went forward with this and we said, hey, this is this is now the law that you can maintain. Couldn't that be used against? Look, they're now saying we can, and they didn't in the past, so they're, maybe if you put in the intent or something.
Well, so that's a reasonable point. Another one of these canons of construction is the legislature doesn't add words, without having an intent behind those words. So oftentimes when we're doing clarifying legislation, we say, is our intent to clarify or correct? So our technical corrections bills have a disclaimer in them that basically says like, this is not intended to be substantive legislation. This is intended to correct grammatical and typographical errors in the legislation
Not
or in the
change.
statute.
Yeah.
Right. So that's another thing, the language that what was in H488. One thing that you could do if you decide to advance that is to include language that says that it is the intent of the legislature to clarify the statute as it was amended, in 1986. It is not our intent to create new rights that were not pre-existing. Something along those lines. And, it's up to the court to decide how much weight they give an intent statement like that, but you could certainly make it clear that your intent was not to, that your position on where the law is and your intent were in a certain direction. Just as easily you could say it's our intent to provide this right prospectively or something like that. And it's all up to how you want to proceed.
All right, did you? Yeah, you all set on? I mean, Representative Burke, did you?
Yeah, no, I was just thinking
Okay.
that I think we have people.
Yeah, okay. Thank you very much, Damon. We're gonna move on to our next item, same topics, but we have Nick Bennett, who's the director of the Vermont Mountain Bike Association and also the Vermont Trails and Greenway Council. And Jeff Nugent is a board member of the Vermont Trails and Greenway Councils. Welcome and feel free to say your piece on this topic.
Great. Looks like things look wonderful. Well, first off, thank you for having us here today. We're delighted to have the opportunity to speak a little bit about the topic of legal trails. It sounds, as you were finishing up your discussion a moment ago, hopefully we can provide a few examples and some illustrations of how these public rights of way play vital roles in communities and connecting people and the landscape. So hopefully this will be helpful to you. And our intent is to provide some stories and kind of real discrete examples that bring this to life. So as noted, I'm Nick Bennett. I'm the executive director of the Vermont Mountain Bike Association. I also chair the Vermont Trails and Greenways Council. And I'm joined by Jeff Nugent virtually, who's a senior planner for the Wyndham Regional Commission and also a board member on the Trails and Greenways Council. So quickly about the VTGC, I don't believe we've testified in committee here before, but we're an organization that represents sort of the collective stewardship landscape in Vermont. So we have over 30 individual organizations from ones like the one I represent, the Vermont Mountain Bike Association, as well as the Association of Snow Travelers. We have the Catamount Trail Association, Green Mountain Club, and then many towns are also part of the Greenways Council that themselves steward trails. So our role is as a collective group that can help sort of raise up and promote the quality, quantity, and access of trails in Vermont. So to touch on a moment, a lot of this topic revolves around the sort of role of private landowners, and did want to note that private landowners are absolutely vital to the outdoor recreation economy in Vermont. Close to 3/4 of trails that are open to the public cross private land. That's very unique in Vermont compared to lands out west that might have huge tracts of federal or state land. And many of those trails are hosted with either handshake or written agreements, but in many cases, those trails are not permanently protected. So it's very clear that a majority of Vermont's outdoor recreation infrastructure is reliant in many ways on the generosity of private landowners. We've seen in certain areas where, and a picture here is from one of our trail systems up in the Brewster River area, where there's a really excellent relationship between those who maintain the trails, the landowners, and there's a ton of appreciation for the role that they play in donating use of their land. The one thing that we'll talk about legal trails are actually one of the vital pieces of public access infrastructure that are permanently protected, or as we have interpreted the law for many years, are permanently preserved for public access. And that provides, again, vital connections. These are trails that aren't sort of generously given by the landowners, but ones we can count on being able to use in perpetuity. So that's kind of how we frame both this deep respect for rural landowners play, but also a desire to protect those public spaces that do really belong to the public. Talk about legal trails for a moment, and I think we've already referenced the map here, and I would encourage folks to go to that map and explore their own communities. There's a really great resource to go in and hone in on legal trails in your area. When I've looked at this, I've found legal trails that I had no idea were kind of in my backyard. But these are public rights of way under the responsibility of municipalities, and in this classification, town roads, but distinct from, and I suspect you've heard a lot from both council and others about sort of the specific details about what legal trails are, but to give the perspective of the trail community and the towns, which Jeff will speak to in a little bit, we have operated for decades under the concept and idea that these are maintained and managed by towns in the interest of the public. They are public rights of way in reasons that a public entity like the select board should therefore manage and maintain those connections. So as again, if you have the opportunity to explore the map, it's been eye-opening for me to even look through all the areas where not just trail systems, but these connections between towns are quite vital and provided by legal trails. So the amendment, which again, I don't believe I probably need to educate you on the amendment, but I put this in here, is that just really clarifying that right of municipalities to have explicit authority to exclusively or cooperatively maintain legal trails. And we wanted to touch on that for a moment. In many of these areas, towns, first off, they have the option to choose whether or not to maintain. They're not responsible for providing that maintenance, but they can do so in what they perceive as the public's interest. And in many cases across the state, that stewardship is done in cooperation with the trail stewardship organization. So an organization, be it representing mountain bikes or snowmobilers or hikers, will work with the municipality to provide that support, because it does cost money. It takes volunteer hours and resources. So the other piece here that is I think just worth emphasizing on our end is in many cases, this fosters cooperation and partnerships with stewardship organizations that can provide support to conduct that maintenance. So as I mentioned before, the maintenance side of it, this is exclusively or cooperatively. So it's an existing common operating model for municipalities. Many of them choose to work with organizations that can assist on stewardship, and that just provides more capacity and bandwidth to keep those trails open in whatever shape or to whatever degree the municipalities see fit. And then the other piece that we wanted to highlight, and again, I apologize if this is repetitive, but at least wanted to touch on it, is the authority but not responsibility, that municipalities can choose, if they so wish, not to maintain trails. And that really creates a distinction with class 4 roads and other town highways, which is really important from a liability perspective, but gives town that leeway to execute maintenance and management as they see fit to maintain in whatever usage they believe their public merits. So last slide before I get to some of the examples from the town authority standpoint. As I mentioned at the beginning, the town oversight of the maintenance of legal trails has always been necessary to function as public rights of way. For us, we've just implicitly assumed, and that's some of the language of the Dillon Law and other things. Again, I'm not a lawyer and I certainly don't want to go down that path, but the idea of, if not stated, perhaps it was because it has been assumed and implied, these are public rights of way. In order for a town to maintain it for a particular use or a particular, for the public, they need to have that authority to conduct maintenance. And in our belief, and we hope that the committee here will either identify language that pursues this, it's creating a clarification rather than creating new law. This is how we've operated. This isn't a newfound right that we think municipalities now have. It's something that just helps ensure that there is no dispute or no confusion about who has that authority to conduct and manage legal trails. So to talk through a couple of examples, one I want to bring up is I live in Waterbury. We have a legal trail here. It's highlighted on the map. This is Cobb Hill Road. It connects the communities of Moortown, South Duxbury, the high school down there, and Waterbury, the town of Waterbury and Duxbury itself. It's parallel to Route 100. It actually links, my son attends Crossett Brook Middle School and actually provides a connection, honestly, around to the high school as well. I also included here a map. This is using Strava, which essentially users upload rides or runs or things like that, and catalogs through a heat map sort of the usage. And you can see those two bright parallel lines running down. One is Route 100, one is Cobb Hill, and it's basically as used or as utilized as Route 100, namely because it's a much safer alternative for folks on bikes, or certainly if you're walking, but it provides an access point that connects those communities off the highway. That particular section of Route 100 too is up and over Moortown Pass, 50-mile-an-hour speed limit. It's not a pleasant place to ride a bike. So this is, again, an area or legal trail that's highly used. It's also part of the local trail organization, the Waterbury Area Trail Alliance. They have an annual fundraiser, a gravel grinder ride that I think every year uses this legal trail as part of its event, and is pretty vital to that fundraiser as well. So a specific example where that legal trail provides connection between two communities, also serves to support the trail organization, is one that the community highly values. Switching over to Roxbury, this is one that with our motorized colleagues. So VASA, this is a network maintained by VASA, the ATV organization. One similar that provides this is on Winch Hill, and it provides key connectors between gas, food, and the trailhead system itself. And the parking actually for this trail system as well is located on the north end of that that legal trail. And all the, I should note as well in these maps, the red dots you'll see in the screenshots, and if you go to the map yourself, those are the legal trails. So this provides really not only vital parts of the network from an experience standpoint, but is connecting users to those assets and resources that they use as amenities as part of their trail experience. Another example up in Stowe, this is right on the edge of the Mansfield State Forest. This is in the Sterling Forest multipurpose trail system. There are two sort of trail pods, and I included a picture off here to the left, where this Maple Run, which is shown on the right here as a dotted red line, it connects those two trail systems. And there is another trail, this 8 Bridges Trail, that in theory connects most of those two, still requires use of a legal trail to connect over to the rest of the trail system. But this is actually a much more open year round. The blue trail there is in a much wetter area and oftentimes has to be closed. So this particularly in the context of a single sort of trail system with two kind of nodes provides a key link between those two trail systems, right again on the edge of the Mount Mansfield State Forest. And the last one I'll give before passing it over to Jeff to talk a little bit about some of what's going on in Southern Vermont is an example from Southern Vermont. This is in the town of Dover, the Crosstown Trail. This has long been a very much loved connection between two portions of the town of Dover. Jeff will talk a little bit about the trail counts, but it similarly is a highly used legal trail. And also over time, the adjacent land is owned by Mount Snow, and I believe the golf course is adjacent here, might be part of the golf course. But trail systems have sort of blossomed on both sides of this legal trail. And now it provides not only key connections between those two sides of town, again, that Jeff can speak a little bit to the frequency of the use, but also has these experiential trails that are multi-purpose. They've been recently upgraded to be adaptive friendly, so usable with adaptive equipment, and provides that kind of experience. So both the connectivity as well as a recreation experience. And then this one as well, on the left side of Handle Road, kind of the terminus of the legal trail, the U.S. Forest Service has approved a project to create a new trail that will access the ridge. There's a pretty impressive ridge line there that connects to Mount Snow. Trail will go up there. So this legal trail will literally provide the linkage between the main town and the kind of West Dover area and those federal recreation assets that the U.S. Forest Service has approved. And I think with that, Jeff, I don't know if you want to pop in and say anything additional about Crosstown.
Sure. Yep. I think it'll be a great segue into talking about other legal trails in Dover. So Crosstown Trail is a little bit different than some of the legal trails in the state, where it's also a formalized recreation pathway. So there's been improvements with SurePack, there's gates at either end, there's signage, there's parking. It looks just like a standard multi-use recreation path. It just happens to coincide with a quarter of a legal trail. And the Wyndham Regional Commission has been doing trail counts there for quite a few years. And as next slide shows, we get 50 to 100 users per day during the warmer weather months on there. So it's quite a popular recreation resource for the town. Dover has about 11 miles of legal trails. Most of them are not in sort of a formalized recreation path format. They're more your typical old roads in the woods, footpaths in the woods, those types of things. And Dover does periodic maintenance to those legal trails as well. It's typically ad hoc. If somebody calls and says, hey, there's a tree down here, the highway crew will go out and clear those trails, but it's something that they do. Most of the legal trails in Dover have 911 road names and 911 road signs next to them too. So there's a bit more formal recognition of their legal trails in that town. And as well, there's a vast local snowmobile club that does maintenance on there, and every year the town authorizes them to do maintenance on it. So in Dover, there's just been this understanding that the town takes care of legal trails and the town can maintain and improve legal trails. This is quite a bit of a contrast to, if you have the next slide, please, the town of Jamaica. So the town of Jamaica has about 18 miles of legal trails, which is second in the state only to Chittenden in the amount of legal trails that it has. So Jamaica has more legal trails than some towns have town highways. And this network here in the southern part of the town connects to East and West Jamaica. It's used by hikers, walkers, mountain bikers, people going out, picking blueberries and raspberries. ATVs, UTVs tend to use it. Snowmobilers tend to use it. It's really a community trail system. It just happens to be an informal one that uses legal trails. And in this case, the town of Jamaica does no maintenance on these or any other legal trails in town whatsoever. If a tree falls down or some washout happens, somebody in the neighborhood who uses these trails just kind of grabs a chainsaw and clears the trails. Trails were even used in Jamaica for emergency access during Tropical Storm Irene. And this is an important component and for emergency access for some of these legal trails. So this just functions quite informally. You go out there, these don't look like formalized recreation pathways. They're just old roads in the woods. There's stone walls down either side. There's old cellar holes and trees and things like that. It tends to work quite well. But again, the town here does no formal maintenance on it compared to the town of Dover. The town of Westminster is also similar in that they don't do any maintenance on their legal trails, but they actually have a Class 4 town highway and legal trail policy that the town has adopted. And that policy even states, quote, that the town shall not maintain Class 4 roads and legal trails. So in this case, it sounds like the town has taken a completely hands-off approach to legal trails. However, there's other policies in that state, and I'll quote, the select board shall exercise control of trails to ensure their integrity as a public right-of-way. And they can do this by restricting use. Say there's this, excess motorized vehicle use that's causing erosion or something. They can have restrictions on that. They can put curfews. They can do vehicle speed, vehicle weight, those types of restrictions to legal trails. They also have a policy that says, quote, the town may perform periodic minimal maintenance on or make repairs to a trail when a lack of maintenance may reduce recreational access to resources. So even though the policy is that the town shall not perform maintenance, which was done so that the town isn't liable for it, they can go through here as a policy, and if there is an issue, they can go through there and do minimal maintenance. Additionally, the town prohibits removal of trees and stone walls within the legal trail right-of-way. And if somebody wants to do maintenance on it, whether it's a snowmobile club or a landowner who wants to improve it for access to their land, they need to make a formalized request to the select board for that. So what this shows is in a town, even where the town does not do any maintenance on legal trails, they have still assumed the responsibility for those legal trails and for the maintenance that would occur on there if somebody wanted to do that. And that's one of the beauties of legal trails is that they're not under the sort of rules and regulations of town highways that exist in statute. It's up to the town to decide what they're going to do with them and what uses can be on them. So in the Jamaica example that I gave, it just works. Again, there's some motorized vehicle use on there, but it's not an issue. If a tree falls down, somebody cuts it, it just works really well. But if there ever was an issue on there, it's possible for the town to go through and do some sort of legal trail policy or ordinance. So these things function really at the will of the town and their residents. Next slide, please. So while many legal trails are out there in the woods, there are some urban examples of legal trails. Minshall Street in the sort of upper left image is the area highlighted in yellow. This is just a few blocks from where I live in Brattleboro. This was a Class 3 town highway, basically a paved city street, a small narrow one though that passed in front of an auto body business. And in 2016, the business owner wanted the town to do something about just the little bit of traffic that was on his street. The street was basically his front yard of his business, and wanted the town to discontinue this Class 3 town highway. However, when you discontinue it, the town has no rights to it. There's no public access to it. And so what would happen there is that the public would lose access to that green highlighted line, which is a Class 4 town highway portion of Oregon Street. So basically there's a connection between Canal Street, one of the busiest streets in town, and the Estyville neighborhood up by Oregon Street. So what the town did instead of discontinuing this town highway was to reclassify it as a legal trail. That meant that the town was not responsible for doing any maintenance on it whatsoever. The town could control the uses on that legal trail, but the public still had access to Oregon Street via this Class 4 town highway and this legal trail. So legal trails serve as that nice sort of middle ground between It's not a full-blown town highway with all the responsibilities that come with that, but yet public access is still maintained because that right-of-way has not been discontinued. There are 3 towns in Windham County that actually do not have any public recreation trails at all. The only recreation resources they do have, besides vast trails, which aren't available to the public during the summertime, are through the Class 4 town highways or legal trails. In Halifax, their town plan states, and I quote, existing town trails being legal trails, provide essentially the town's only opportunity for public outdoor recreation. They also serve as important corridors through backcountry areas. Then there's a policy in their town plan to, quote, maintain the existing physical condition of town trails to promote their use for recreational purposes. So here it's a town policy to maintain their trails. In the lower left image is Josh Road, and the picture on the right there is my bike in front of a beautiful cellar hole on Josh Road. Josh Road is a legal trail, and in this case provides access to a cemetery that's out in the woods. It's a public cemetery, hasn't been used in years, but just an example of public access to not just a recreation resource, but in this case, an actual town cultural resource. A few more examples. Up in Marlborough, there's a legal trail that goes out to South Pond. It's part of the Marlborough Nordic Ski Club trail system out there. So we're using trails not just for summertime use, but also for winter use as well. There is also a legal trail in Dummerston off the end of Fallbrook Road that serves as an important trail connection there. Just recently, it was incorporated into the last missing link of a 20-mile trail system from Dummerston Center up to Grafton. And actually it's called the Missing Link Trail. And part of that is because this legal trail exists to connect the Putney Mountains Association's 2 separate trail networks, one in Dummerston and one up on top of Putney Mountain. So that provides a very important connection there. Next slide. We're going to slide slightly west of Windham County over into Bennington County. Reedsboro is still part of the Windham Regional Commission area. However, Reedsboro is at the eastern end of a 9-mile long corridor of Class 4 town highways and legal trails that run from Reedsboro almost into the town of Bennington. This corridor crosses the southern end of the Green Mountains, goes through Green Mountain National Forest land, and is used by both VAST and VAZA as part of their trail system. Again, the eastern edge of that is part of the Reedsboro legal trail system over there. And then on the map, there is a red dotted line that directs south. That was a legal trail that's used by VAST and VASA to connect another portion of Reedsboro's ATV trail system up to this one that goes through the National Forest. So I think that's pretty impressive. A lot of the legal trails are maybe a mile or 2 long. In this case, this is part of a 9-mile long trail corridor. So in summary of what I've presented, again, as Nick said, the assumption has always been there that towns have control over legal trails and that they can actually perform maintenance on them. And this has not only just simply been casually assumed, but it's been incorporated into actual town policies, not just in town plans, but in actual standalone Class 4 and legal trail town policies that, directly state that the towns do have control over maintenance of these legal trails. And with that, I'll turn it back to you, Nick.
Thanks, Jeff. And I think Jeff summarized it nicely. The kind of highlight from the beginning is that the really permanently publicly accessible trails are a minority of trails in Vermont. And legal trails provide a key cornerstone of those permanently publicly accessible trails. It's also our firm assumption, as Jeff noted, in many of the ways these towns have been operating, that authority to maintain has been implicitly assumed by towns for many years. So
We have a question.
Oh, yeah, go ahead.
Sorry.
That's not a question. I just wanted to say hello to Jeff,
Oh.
who's my constituent. Good to see you. Thank you for your testimony.
So, I mean, I think we mostly summarized it. The only other things I would have to say is that, this, again, if there's a way to frame this amendment as was noted earlier, as a clarification of the previous law, I think it's something that would really help assert the role that these resources play in recreation in Vermont. So with that, again, delighted to have Jeff. Jeff is truly an expert and was gracious to share a lot of examples in his corner of the woods. So happy to take questions.
Thank you, Nick and Jeff. I mean, this was very helpful, I'd say, for me and maybe for the committee. Do you have any examples where landowners have pushed back? Maybe they didn't like the maintenance, or they don't like, maybe more people coming, or maybe push back saying you're not, the towns aren't maintaining them. And I think you gave us good examples that mostly it's not necessarily towns, it's organizations, a lot of different ones to maintain these public ways. So have there been any other examples or pushback that you're aware of?
Yeah, and Jeff might have some better examples, but an example I gave of Cobb Hill in Waterbury, when I first moved to the town, I encountered no trespassing signs on that trail, which confused me because I looked at the town map at that time and thought this was a public right of way, and I turned around and went home. When I spoke to other folks and were directed to some of these resources, I realized that those signs had been put up, I wouldn't say illegally, but not accurately in terms of it wasn't their land posted in that way. So those landowners clearly didn't want people using that as a thoroughfare. But going back to the start, as those roads were classified, that was a public right of way. So that was perhaps it's more, there are a few, and obviously there's the current court case where there's been overt sort of conflict or pushback. In some cases, I think what you're seeing more of is those landowners sort of more subtly putting up signs and things like that. And one of the things I think this legislation or this amendment would help do is to clarify that what a legal trail is, that it's a public right of way, and that the town has the authority to maintain it. But Jeff, I don't know if you have other good examples.
I was going to use that exact same example. I've gone out there and I've encountered no trespassing signs. They're done in a way so that it looks like the road itself is private, but I'm not seeing, bars and chains across the road. I'm not seeing a real blatant stay out. This is private property. And I think some of that is being done so that the town or so that the adjacent landowners can try to limit the amount of use on there. Oftentimes they're maybe worried about motorized vehicles going back and, going off the legal trail and into their adjacent property. But I haven't come across any examples of real blatant prohibition by adjacent landowners, but there is certainly the idea of just, people kind of wanting to keep things quiet back there.
And I'm going to assume this is true, but I'll ask the question. Are there some of these legal trails where you have signage? Hey, this is the whatever, Cumberland Trail. And if you keep going this way, you're going to get here. Or if you go this way, you're going to get there.
Yeah, it's a great question. I'll give an answer and then Jeff, you might have a better answer. But I think what you see is it's just a huge variety. There are areas where these legal trails make up parts of very popular existing connections or trail networks where they're almost captured as either part of that system. There may not be a sign saying this is the Maple Run legal trail, but they're part of that system. Whereas there are other areas where, as Jeff noted, that are much more informal, that they just simply are there and the town has decided not to really take a position other than perhaps having, some of the rules and regulations that state if they need to, they can get in there. So I think that the short answer is it depends. It's widely, it's a huge variety. And I think if anything, again, we hope that this topic is resolved in a way that helps us actually be able to promote legal trails even better. One of the resources we linked to was the Trails and Greenways Council now has a page on our site for legal trails with some Q&A. It'd be great to even update that further and allow towns to really lean into these as resources. Jeff, I don't know if you have anything to add.
Yep. Yeah. As Nick says, many of these have been incorporated into public trail systems, oftentimes by different nonprofit organizations or by VAST or VASA. The example I mentioned in Dover, they look like standard street signs, Cheney Trail, Hathaway Trail, White's Hill Trail. So they're maybe not identified as trails in the traditional sense with kiosks and such, but they're definitely out there and they're definitely noted as a public resource. Other times it's just, you kind of have to have the map. And the neat thing about legal trails is that it sort of allows that informal level of exploration in some ways too. So they sort of fulfill this niche between formal trails and just bushwhacking, in that it's in some cases a sort of just a lower level of going out there and exploring the place. There is actually an example in Westminster. There's a legal trail that people live on, and it actually has been improved for motorized transportation by the people who own land on it. But it also serves as a trailhead for the Windmill Hill Pinnacle Association trail system. And there is an official town highway sign that says, trail, public right of way, not maintained by the town. So those types of signs exist too, identifying it as a public right of way, but there is no town maintenance on there. But summary is, it's a hodgepodge. It's all over the map. There's so much variety in legal trails, and that's a great thing about them.
Thanks. Any more questions? If not, thank you very much for coming in and giving us your testimony. We appreciate it.
Thank you so much.
It's very